listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law and hanging out in the courthouse with remotely my co-host Paul Doroshenko.
Hi, Kyla. I'm hanging out in the unused office here in Richmond. Was a used office, but we moved some bookcases, so it looks like you've got the same dismal background I have.
Dismal background time. Yeah, I know. I was earlier on MS Teams and I had lovely background for court, and now I'm this.
Yep. Well, you're in the courthouse. You're in like a barrister's lounge or something.
Interview room.
Interview room. Okay.
Yep.
Well, it's an interview room that's got some forms behind you.
Yep.
I have a hole punch.
Wow.
It's like a luxury. At least I have a come there.
Today is a dark day.
Okay.
Dark day. So the Supreme Court of Canada released a pair of decisions that just really did not go the way I hoped they would go. Went the way I knew they would go, but not the way I hoped.
No, one remains optimistic all the time, but there's really no good reason to be optimistic.
Yes. So you've probably, if you've been a longtime listener of the podcast, heard about this issue called the Goldson issue, related to the Alberta Court of Appeals decision in a case called Goldson, which pertains to the admissibility of breath samples. And specifically, for background for, obviously, Paul, when you provide a breath sample into a breathalyzer at the police station, it's checked for calibration using something called an alcohol standard, a canister of alcohol-laden gas, or sometimes a solution that's meant to simulate alcohol-laden breath at a certain concentration. And that alcohol standard is meant to be certified by an analyst at the RCMP lab who orders a bunch of the same lot of standard. They pick out 10 bottles randomly, they test them, they make sure it's consistent with the target value, and then they go, check, yep, this is a good standard. Very important. It's central to the reliability of the ultimate result. It's calibration.
Yeah, basically holding out that this is a scientific process, and therefore you've got a standard against which you're going to measure it.
Yes. But when it comes to impaired driving prosecutions, because you don't actually, ever get to challenge any evidence really, what you end up getting is a certificate for the breathalyzer reading that says in the certificate, I, the qualified technician, checked the calibration of the approved instrument by means of an alcohol standard, which was suitable for use as certified by an analyst, and it was found to be within 10% of the target value. And then you also get in your disclosure a certificate from the analyst that says, I checked the alcohol standard and it's all good. Trust us, we're government. 2 pieces of paper that essentially say that together cumulatively.
Now, if you're in the United States and you are a defense lawyer or you're an accused person, what you do is you say, well, I want to know whether or not that lab did it. Did they actually randomly pull it out, or did they pull out one and test it? Or did they not even do it because it's a lab? And all of these labs in the States have been found out to have screwed things up. And the lab in Canada, we found out screwed things up. But in Canada, there is this absolute belief in the honesty and perfection of the lab and the RCMP to the point where we are not even expected to question it.
No. In fact, we're pretty much not allowed to question it unless we bring an application in advance of trial to question the analyst, and we have to provide a foundation for why we should question them, which foundation can only come from the document where they say everything's fine. Pay no attention to the man behind the curtain.
So essentially, we don't get to see what they're doing. We don't get any disclosure about what they're doing. We get a document that says they did it and they did everything correctly. And we don't even get to check whether or not they did everything correctly. We don't get any notes about it. We don't get any disclosure about it. We don't get anything. It is quite literally, don't pay attention to the man behind the curtain.
So you would think with all of these like restrictions that directly affect somebody's liberty at the end of the day, that the government would write legislation that said, oh, well, you have to at least file all of these documents in court to make sure. Absolutely. That this is correct. All of this information needs to be filed before the judge. We can't just have hearsay in one analyst course or in one qualified technician certificate about what the analyst said. And of course, the government argues, he says it's good, and he's got that it's good from somebody else who says it's good. How could that not be trustworthy? All you need is one person saying somebody else said that it was good in order to meet the statutory requirements for the breathalyzer to just be just fine, hunky-dory, everything's good.
Essentially hearsay of a process that they weren't even involved in.
Double hearsay, really.
Provided in the form of another certificate.
Piece of paper.
Another piece of paper saying that everything was good and we're not giving you the first piece of paper.
Yep.
So you haven't been given the first piece of paper that says it was tested. It's just me giving you this piece of paper that says everything's good.
Yeah, the judge doesn't get that piece of paper. You get that piece of paper in disclosure, but they don't have to give it to the judge. The judge is just expected to trust the police by law. And this was the issue in the Goldson.
And this relates to the entire process right to the end of the sample. So basically, the person provides a sample that says over 80, and you don't get to question any of the process that led up to it. That machine's functionality or the standard being used. Okay.
Yep.
So Goldson.
So Goldson deals with this situation where Mr. Goldson had said, no, you need to file both pieces of paper. You have to file the one from the qualified technician who operated the instrument, but you also have to bring the one from the analyst who said he analyzed, or usually she, analyzed the standard. How hard is that? Really, and this is what the dissent says in the Supreme Court of Canada decision, and these cases aren't called Goldson because Goldson didn't get leave. 2 cases out of New Brunswick and Nova Scotia got leave. And in Goldson, the Alberta Court of Appeal said, yeah, I mean, how hard is it? Bring a piece of paper, file it in court. It walks into court on its own, so just hand it all up and problem solved. Bing, bang, boom.
Don't get to cross-examine on it. It's a shortcut, a statutory shortcut that prevents us from being able to cross-examine. The criminal code says it's going to be there and it exists. File it.
And the Supreme Court of Canada basically said, the majority, with one dissenting judge, said, no, it's good enough that it says in the qualified technician certificate that everything was fine. You get disclosure of it. So if there's a problem, then you can apply to cross-examine the qualified technician. And if they tell you they're going to produce that analyst certificate, then you can also apply to cross-examine the analyst if there's an irregularity in the document, which there's no irregularity in ever. It's not like they're going to send you a certificate that says, actually, it wasn't correct, but we sent it out to be used anyway.
I mean, I personally don't believe that it happened a lot of the time. That's my cynicism. But you would think at least that there would be that requirement to file it, as the Alberta Court of Appeal thought. But in any event, it went to the Supreme Court of Canada. Decision came out this morning. Kyla says it's a dark day. I knew it was an ominous dark day yesterday because the rain and the here was just such a downer of a day yesterday. I was not optimistic. Kyla was not really optimistic either, but we were realistically and always hoping to be surprised. The Supreme Court of Canada went the wrong way. And I watched some of the argument last night, the video for it, and I was extremely disappointed with the questioning. And, I don't recognize these judges anymore, but like the ones that I do, I'm like, why are you asking that if you're just going to reject all those arguments? Like, why are you pretending not to know what the steps are? And now you expect this lawyer who's working here to answer this question that's here when she's trying to explain to you the statutorily required purpose that leads to the shortcut, and you're asking about the hearsay aspect of it and not understanding the purpose of the standard, and then asking her to explain the purpose of the standard. When we've used standards, even in the old breathalyzer 900, there was a vial that was a standard, right? This is 40 years of a standard.
Yeah, the questioning was disappointing. What was also very disappointing was the responses. From my perspective, the responses to the questions, because I believe deep in my soul that maybe Justice Rowe, and I know that's who you were referring to on the questioning, but there's also Justice Kazurier, but both of them, Kazurier less, Jamal maybe, but Rowe for sure. I think he was looking for counsel to make a certain point. I don't like the intellectual dishonesty of if counsel doesn't make that point that I want them to make because this is where I want to go with this, I'm not going to engage with it. But
I don't know why, if that's the case, you wouldn't say, why are you saying to me that this, and then make the point and let them say, yes, that's what I'm saying.
yeah, well,
Unless you try to trick people.
there was a silver lining though, Paul, at least one little teeny tiny sliver of silver. The dissent.
Yeah.
A
That's just,
little-
as you were saying that, I was just thinking, next time you run into one of those judges in the Air Canada lounge, give him shit for him.
I can't do that. I don't want to get disbarred for
You're,
worthy cause, but
they're always so nice to you. I don't go up to talk to them, but they're always very nice to you.
they are. Well, if I run into Justice Côté in the Air Canada Lounge, I might give her a hug because she was the lone voice of reason, and she agreed with me. And like literally in the hearing, she said to Crown in their argument in Crown, I did not like their argument at all. They were a little bit loose with the truth about some things.
You and I have noticed that every time. Every time. It's like, are they misinforming that Crown so they can go into court and deceive the court? Because I'm not assuming that that prosecutor is trying to deceive the court.
Oh,
It can be that somebody has explained it to them in a way that they don't understand it, or that they've had it explained to them in a way that they are then going to go in and say something that is inaccurate because somebody else wanted them to say that.
well, I mean, yeah, the crowns that are doing those types of arguments, those Supreme Court of Canada arguments, are not trial level crowns, so they aren't the ones engaging with the subject matter daily. But I also like got a little perturbed when the Crown talked about his own like extensive knowledge of the operation of breathalyzers. I'm like, go away, go away. Like my extensive knowledge of this. Like, okay, buddy. Uh, anyway, you might have missed that part. Where was I going? Oh, the dissent. So Justice Côté asks him in his submissions, but isn't this like not that hard? Like, I mean, honestly, isn't it not that hard? You just file a document. But that's all they're asking for. Why is this such a big problem for you? And his response was, well, we have found that when we file the document, defense counsel turn around and bring all sorts of technical arguments and applications and try and complicate things. I believe we refer to that as defending our clients, pursuing every angle, making sure that evidence is only admissible once it's been fully tested, doing our job.
Well, the not that hard argument has never been a good argument as far as I'm concerned. Just because something's easy doesn't mean that you have to do it. But the fact of the getting to skip over all of those evidentiary steps by simply filing a document would suggest that it's not that hard, and you're getting to avoid all of these other hard things.
Yeah.
That's where it comes into play to me
Yeah.
on the not that hard argument, because you're getting that gift. You know, it's like, I don't want to open the gift. It's so hard to open the gift. They're giving you a gift.
Yeah. Yeah, it's ridiculous.
Harder would be to have the gift and never be able to open it and need the thing that's inside, right?
Yeah. So yeah, I don't know.
But I didn't like my point. Your point was the response.
Yeah.
My point was that in the dissent is not the powerful thing, but there is something powerful in the dissent.
Which is that Justice Côté leaves the door open for us. So it's going to make our jobs harder, but defense counsel, unlike Crown, never shies away from it getting more hard for us because it's always going to be, no matter what. And that is that she said the majority's interpretation of the statute as not requiring them to file the actual certificate of analyst probably leads to unconstitutionality because you are denied your right to make full answer in defense, and the case is decided with a finding of guilt, essentially a de facto finding of guilt, where there could still be a reasonable doubt. And that's a problem.
See, I think it's a Section 8 argument because I think it's taking away the ability to be able to challenge the search and seizure, which makes it no longer reasonable.
Yeah, I mean, that's another way of looking at it. The point is, we have that little crack. She says, here's your pathway, defense counsel. I see you have a problem, and we want to fix that problem. So
I'm very happy you read the dissents. I really wish I had started doing that in law school. And any lesson for anybody who's in law school right now who has any interest in any specific area of law, read the dissents because there's very often something there.
that or just helps you maintain your sanity when you read a decision that just
At least you know there's one other person out there. There's one rational person out.
yeah. Anyway, I have to get to court in just a few minutes, so this is the only topic of the week other than
the ridiculous driver of the week.
Which is an amazing one, by the way. And you found it, and I love it. I love it.
It's actually all over the news, so
Yeah.
you probably already heard about it, but we could not make it not have it as the ridiculous driver of the week because it's so good.
So this is a man in Hamilton, Ontario, continuing with our Canadian ridiculous drivers of the week, 36 years old, and he decides that he is going to take a city bus on a joyride with the passengers still on board. And he doesn't just, do something out of the movie Speed. No. He drives the bus on the bus route.
Well, it didn't follow the route.
Well, okay.
Stop at the stops, pick people up, drop people off, refuse one passenger from riding on the bus because the bus pass had expired or the whatever document you need, and continued on driving lawfully and safely. Now, interestingly, when you wrote your Weird and Wacky Wednesdays this week, I noticed that there's three of them. There's three different instances in like the last decade where this has happened in Canada. This is not the first.
Were you talking about the train guy, the guy who kept stealing trains until the point that he got like a?
No, that was we discussed that in some other one. No, it was you covered it. It was in your Weird and Wacky Wednesdays this week. There's three separate people where they took the bus. Take the bus.
Why not?
When I was a kid, the ETS, the Edmonton Transit System, used to have a little ad. Take the bus, take the bus. Yes, I'll take the bus. If you take the bus, it will get you there. Take the ETS, it will get you there. And all I was thinking when I was seeing this was, hey, man, they're telling you to take the bus.
Power of advertising.
We've had occasional case where our clients have taken a taxi and they actually took a taxi. And you're wanting to go into court and make a joke. Well, Your Honor, he's been told all his life, if you've been drinking, take a taxi.
You did make that joke in court once.
Did I?
Yeah.
I think I did. I mean,
you had the right judge for that delay.
I hope it will come out. Yeah, I have to be careful. The
right crown, and no high school students in the courtroom that day.
Yeah, I guess. But yeah, you're always told to take the bus. It's good for the environment. Take the bus.
Exactly. There you go. Well, that's our podcast. If you stole a bus, you can give us a call at 604-685-8889, although I would highly advise against it. If you have an impaired driving case and you're worried about being found guilty with a reasonable doubt, give us a call or find us online at vancouvercriminallaw.com and tune in next week for another exciting episode of Driving Law.